Good morning, Board Member Flores and members of the board. We are now live and recording.
Good morning. This meeting of the Agricultural Labor Relations Board is called to order at 10:12 a.m. I will now call the roll. Board Member Broad.
Present.
Board Member Lightstone.
Present.
Perfect, and I will note that we have a quorum present. I will also note we have a little bit of
Can
an
I
echo.
interrupt for just a moment? We have an echo in the room. We'll need to have the mics turned off and volume turned all the way down on any machines.
Trying.
And we could test it by just,
I'll just get off in case it's me. Well, I'm off.
okay,
Hello?
I think I was able to mute
Got
the
it.
machines.
Thank you. So with that, I will note we do have quorum present at our location in Sacramento. Also present from our staff for today's meeting is ALRB Executive Secretary, Mr. Santiago Avila Gomez, who is providing technical support. The board has called this meeting to provide an additional opportunity for stakeholders or interested parties to make public comment relating to the AB 113 implementing regulations agenda item. We will start with members of the public who have contacted the board either by email or phone and asked to be placed in the public comment queue. They will be called in the order the request was received. If you did not previously contact the board and wish to make a public comment, you can make a request in the Zoom chat function or raise hand, or email Santiago Avila Gomez to be placed in the queue for public comment. Please note, we ask that you use the chat feature only to indicate that you wish to make comment. Substantive comments in the chat will not be made part of the public record. We ask that you also provide your name and organization if applicable. This information will become part of the official record of today's proceedings. If you wish to speak more than once, please alert staff to have your name placed back in the queue. If you experience technical difficulties when you are called, please reach out to us via the Zoom chat function or email, and we will get back to you. We have limited capabilities for managing participation during the meeting and during the public comment periods. We ask everyone who is not speaking to place their phones or Zoom on mute and wait to unmute until you are called to speak. You can also see these instructions on our agenda, which is posted online at alrb.ca.gov, located on the ALRB homepage under News and Information. Please note, the board is unable to discuss or opine on matters that are currently before us. Before we hear public comment, I will turn to the committee co-chair, Member Broad, for any statements or remarks you'd like to make.
Good morning. We're well along in this process, and but it's very critical for us to hear from the public about this regulation package so that we can make sure that whatever we do with intentionality, understanding that, you know, that our decisions in terms of regulatory language can, you know, affect people's substantive rights, and we need to try to get it right as much as possible. Obviously, we're dealing with a newly implemented statute, so there's a lot of new ground to tread here. We've been very deliberate in trying to solicit comment all along, including a pre-comment public process. After we hear from comments today, the written comment deadline to receive further comments is July 22nd, and just because someone has made comments in the past, they can continue to make comments right up to the deadline. At that point, the subcommittee will review all the comments that were made and make any recommendations to the full board regarding any further changes. If we recommend further changes and the board accepts those further changes, then that would trigger another comment period. So the process could be drawing to a conclusion, or perhaps it will go on a little bit farther, longer, if we're inclined as a board to make further modifications of the regulations. Today, we will hear comments. We may ask questions. We may not ask questions about certain things. That doesn't mean that we're ignoring anyone, but it does. But we are listening very carefully and have very carefully taken into consideration the comments that we've received so far. So with that, I will return it back to our chair for the day, and we'll proceed. Thank you.
Thank you, Member Broad. So at this time, we will turn to requests that were made prior to the meeting. Santiago, can you please let us know if we received requests to speak? And is there someone in the queue?
Yes, Mr. Martinez indicated the wish to provide comment. You can unmute your line and provide your comment at this time.
Hi, good morning, everyone. Good morning, board members. Thank you for the opportunity to have this comment. We don't get a lot of chances to speak with you as a group, so certainly appreciate this. So yeah, we have several areas of concern that in consultation with the UFW leadership, the UFW organizing team, I've been asked to bring to your attention. Certainly I'm not going to go over our entire comments that we submitted in writing yesterday. I trust hopefully you've all received those and we'll have time to look through them. But I do want to go over the areas that we are most concerned with. And not necessarily in order of importance, but certainly they are all important to us. So the first area I wanted to address with you, which we've expressed concern about this from the beginning, is the provision of a tally by the regional directors. We've objected to that from the beginning. We think in close cases, it will actually create an incentive for agricultural employers to file objections in the hopes of overturning the election or changing the results. We don't necessarily see a need for it. We understand that in secret ballot elections, obviously everyone knows the vote count because there is a vote count. In our comments, we've identified what we believe to be the prevailing practices in this area where other jurisdictions use proof of support, majority support, or card check. Specifically, we've identified several statutes that are administered by California's Public Employment Relations Board, none of which provide a tally. They just simply provide whether or not the union has obtained majority support. I think the board is aware also that New York's Public Employment Relations Board also does not provide a tally. They just, again, indicate whether or not majority has been achieved. And even in the NLRA, our experience with, obviously this is voluntary card check procedures, is there's just a thumbs up or a thumbs down. Oftentimes a third-party neutral, like an arbitrator, is assigned to count cards for purposes of recognition requests under the NLRA. And again, as far as we know, the prevailing practice there is also to simply state majority has been achieved or not been achieved. So again, we don't really see a need for it under the ALRA. certainly, if there's concerns that the board has on this issue, we'd like to hear them, but we certainly would request that a tally not be provided by the regional directors, that instead they just simply state whether or not majority has been achieved.
Can I ask a question?
Sure.
So, can you sort of run through, if there wasn't a tally, how the objection process would go forward, how it would work?
Yeah, I think employers would obviously still have the right to object. And if they had evidence of either regional director misconduct or regional director mistake or union misconduct in the gathering of cards, I think they could still raise that. That doesn't prevent them from raising it. I think the board can still decide whether or not that conduct affected the election, and certainly the board can have that information, but I don't see the need to actually provide it to the parties in this situation. It's just parties object to elections under all these other statutes without knowing the actual quote unquote count. So I'm not sure that that's necessary for the board to assess misconduct.
Well, what if it's not misconduct? What if the issue is eligibility? But don't they, like, if someone wants to say, I guess either side, but say someone is not eligible to vote because they're a supervisor, don't they have to know who the individual is in order to raise the objection with a degree of specificity to state a prima facie case to support the objection?
Well, it seems like with respect to eligibility issues, the board has set out a separate process, which the union is generally okay with, and it seems as part of that process, the parties will know who is deemed eligible and who is not deemed eligible. I don't want to get into specifics of any pending cases, but we have cases already where the regional director advised the parties which employees were eligible and which were not. So both sides knew, employer and union, in situations where eligibility was a dispute. So I think in eligibility cases, certainly the parties have to know which employees are being considered eligible and which aren't, especially if you have a situation with employees not on the list or employees taken off the list, right? I think that's part of the natural process there.
Thank you. Okay.
Okay. The next
Maybe-
area of concern that we have is how to interpret this section in the statute, which requires the employer's response within 48 hours. Right. So our position and certainly our input into the drafting of this provision was that historically there's been a lot of manipulation of employer eligibility lists by employers. They either add employees when they add employees from other contractors, perhaps related companies, or sometimes they exclude employees, particularly from crews that they perceive to be as strong supporters of the union. So for us, 48 hours is a reasonable time. Employers already know they're on notice. They have to comply with providing eligibility lists. There's general provisions in the labor code, I believe it's Labor Code 1174, that require accurate record keeping already statewide. So we don't want to allow additional time to manipulate lists, and certainly the statute says 48 hours. It doesn't say 48 hours, but excluding Saturdays, Sundays, and legal holidays. And, we understand that the exclusion of Saturdays, Sundays, and legal holidays comes from an existing board regulation that actually says by its own terms, it applies to the rules or regulations that the board has set out. But we don't believe regulations in this area can trump a later enacted statute. So we're very concerned. I think we set out an example in our comments where potentially an employer could have 4 days, double what's in the statute. If the union files a petition, on Thursday, anytime on Thursday, then the response would be, excluding Saturday, Sunday, would be Monday. And that's certainly not what labor envisioned when they provided input on this 48 hours. I don't believe it's what the legislature envisioned, and I just think it's too much time. This is a quick process. The regional directors are already dealing with a lot of issues that they have to decide in 3 days, right? So, and again, not to speak about pending cases, but I think the board already has enough experience seeing what happens when an employer doesn't provide a response in a timely manner, provides an inconsistent response. I think those all create problems and difficulties for the regional directors to be able to make decisions within the remaining 3 days of that initial 5-day determination period. So I think compliance with 48 hours is really necessary. And I with all respect to the board, I don't think the board has the authority to decide something different because maybe it's convenient to the parties, or maybe someone else wants it. I just don't think the board has authority in this area because the statute is very clear.
I don't have any questions. Oh,
Okay, for the same reason, we would really request that the 5-day determination period by the regional directors be 5 days and not extended by Saturdays, Sundays, or holidays. Again, the statute is clear on this. We certainly are sympathetic to the fact that the regional directors and their staff are, under a lot of demands to decide a lot of things, whether it's unit issues, employees that may have been excluded, supervisory issues. It is a lot of work. It is a lot of work to do in 3 days. But again, the statute does not exclude Saturdays, Sundays, and legal holidays. And, we certainly appreciate that they're working hard and their staff is working hard, but so are the farm workers, and most farm workers don't get Saturdays off. Most don't get legal holidays off. In union contracts, we try to negotiate for legal paid holidays off for farm workers, but the vast majority of workers just don't have that. So again, in these tight timelines, we don't think the board has authority to go against what the legislature said in this area. Certainly, if the board, if there's a gap and the board sets regulations regarding certain things, that's well within the board's authority. But we don't think this is an area that the board can deviate from either.
Yeah.
I do have one question, which is, as a practical matter, if 3 of the 5 days to, let's say it's a holiday weekend, and 3 of the 5 days are that the regional director is required to do this investigation are on the holiday, and let's say the employer is closed on that holiday, the employer's administrative employees are not working on those days, and they're the ones who might have to reply or respond to requests for information. Does it concern you potentially that could stymie the regional director's investigation, and the requirement that it be done within that 5-day period as a practical matter?
That's not a concern for us, because I think if the rules are set out ahead of time and employers know, and in the initial notice that the regional director sends to the employers, they state, we note that, there is a holiday upcoming. Under our rules, responses are still required on holidays. And of course, there's the regulation, which we fully support, about presumptions where employers either are refusing to comply with requests, frustrating the regional director's investigation. So the regional director has those tools available. But to answer your question, I think if the rules are set out ahead of time, employers can make arrangements to figure out how to comply with these responses. And, if that means staffing people on holidays, then that's what it means. But again, most of these systems are now computerized. We're no longer seeing things where we have, handwritten paper records of who's working and who's not. Payroll is very electronic now. Time records are electronic. These are all systems that they should be able to have a handle on and master and produce these things within a short time period.
Thank you.
Thank you. Another area of concern, is the proposed notice in question and answer period that the regional directors are proposing. We're concerned with this for a lot of reasons. I think in our comments, we set out the fact that this was not part of the negotiated language that included really at this point, years and years of discussion with legislators, with the governor, with the other side. And we're really concerned because you can't police the comments out there. Unless there's an agreed upon script by everyone that was agreed upon by the legislature, you just don't know what's going to be said. We've had a history of unfortunate experiences with noticing in the secret ballot election process where maybe not necessarily regional directors, but their staff are giving essentially really strong anti-union speech to workers, telling workers they don't need unions, telling workers that the union's only going to take 3% of their paycheck and give nothing in return. Certainly, we would not expect that from the regional directors, but again, most of the time their staff are out there, and I just don't think you could police the comments in the Q&A period. And I think it's a recipe for increasing objections, increasing litigation. It's either the comments made out there are either gonna upset the employer, they're gonna upset the union, they might upset both. We think this is far beyond what the legislature intended. The legislature sets out what the board and its agents are to do when they are dealing with a majority support petition, and doing a Q&A and notice period is not part of that. We think the benefit of this procedure is, again, allowing workers to exercise their choice in the privacy of their home without feeling that they're being supervised in this process, either by the employer or by the government. And I think government supervision, for lack of a better word, government surveillance is a concern for us, that workers may be hesitant to exercise their rights if they now know that they are being surveilled by not just their employer, who's now on notice of what's happening, but the ALRB. So we have very serious concerns with this. We think it's beyond the board's authority to add essentially a step in the process that was not considered, discussed, or approved by the legislature. So we definitely would object to that provision in the regs. We also set out in our comments why we think the regulations should allow for unions to file objections. There's provisions under 1156.37. I think J and K concern potential remedies for employer misconduct or employer unfair labor practices. They set out those terms in different portions of the new bill, stating on one hand unfair labor practices and on the other hand misconduct. And to us, at least when we were providing input into this part of the process, misconduct is something that is proven in the context of election objections. Unfair labor practices are clear what they are, unfair labor practice. Election misconduct essentially can only be proven in the context of objections. And we don't think the legislature would have provided for a remedy for employer misconduct if the union couldn't prove that remedy in an objections proceeding. So we certainly don't think there was an intent on the legislature to deprive the union of an opportunity to file objections, which they've had since the inception of the act. We don't obviously, this was a procedure to increase the opportunity for employees to select a bargaining representative. And if unions are deprived of the right to file objections, then they can never prove misconduct and therefore never seek this remedy unless the general counsel issues a complaint. And we certainly don't think that remedy was intended to be tied to the issuance of a general counsel complaint. So we would really urge the board to adopt language that would allow unions to file objections in cases where misconduct affected the results of the objections of the election. And moving on, we saw that the board was trying to grapple with when does an MSP campaign start for purposes of 1156.37 J and K. I think the language is if an employer engages in misconduct during a majority support campaign or something to that effect. So we're certainly concerned and opposed to setting a 10% signing of card threshold as the marker, so to speak, for this remedy. We don't think, again, there's anything in the statutory language that would support that. I think one potential big problem with it is if employers get an early wind of a campaign happening, then it would actually incentivize them to embark on a really aggressive scorched earth tactic to try to prevent the union from ever getting to the 10% and therefore from ever having access to these remedies available under subdivision J and K. And obviously we think that's the opposite of what the legislature intended. For us, during a majority support campaign begins, when the first card is signed or when you have your first meeting with workers. And if there's going to be a bright line, we would certainly advocate for that, as opposed to the 10%. Again, we're just really concerned that would incentivize employers to hire anti-union labor consultants and to have captive audience meetings and to really scorch the earth in trying to oppose unionization. Okay, if there's no questions on that, our next area of concern is requiring in-person filings and submission of originals for purposes of either the petitions or proof of support. How we've been working with the regional offices to date is we've been filing everything electronically with PDF scanned copies of the authorization cards. And usually within the next day, we're able to get the originals of the cards to the regional offices. I think this is going to be especially important if you have workers in areas that, are more than 2 or 3 hours away from the regional offices. With technology these days, we're not dealing with blurry images of authorization cards. We're dealing with high quality scans, PDF scans that are very clear. And then, like I said, originals are usually provided within 24 hours. We're not dealing here with those old fax machines that had like really blurry images of things. We're again dealing with high quality PDF scans. There's usually no issues with that. We haven't experienced any issues or concerns from the regional offices about this procedure. So we, just to maximize the ability of farm workers to vote during MSPs, especially with these very quick timelines of whether we're dealing with the 5-day initial determination period or the 30 days, it's entirely possible that the union's working on a deadline to get cards in at the last minute. And certainly we would hate for workers to be deprived of the opportunity to join a union because they couldn't get their original cards to the ALRB offices in person in time. So we would really urge the board to amend this to allow for electronic filing and then a reasonable period for submission of the originals. And with respect to that format of the cards, we don't have a strong objection to the board's proposed format, but we would like some language that gives the board and the regional directors discretion to accept cards if they're not in this exact format that's proposed by the board. The main reason is, we could have a lot of versions of cards that are being used now that are valid for a year. And then when the board adopts the regulations, those cards may technically be outside of this format. So we don't want to exclude submission of cards that, that were signed, for example, today, based on adoption of this regulation in 1 or 2 or 3 months. We also just think it makes more practical sense for the board and the regional directors to evaluate the cards to determine whether they reasonably authorize union representation. Again, we don't want employers to file objections, for example, if a card doesn't include a certain piece of information that is not considered critical by the board. So we want the board to have some flexibility and the regional directors to have some flexibility if they need to in accepting cards that don't necessarily comply with this exact format. We're also concerned with the board providing downloadable copies of the cards. If the board does that, we would ask that the board adopt a regulation that employers cannot use or abuse their cards in their efforts to make sure that workers don't sign cards. There certainly is precedent for that in the NLRB context. There's strict rules against defacement of election notices. There's rules against defacing the notices in a way to indicate that that one party or the other is using the notice to suggest that the board wants the workers to vote for the union in a certain way. So we certainly want the board to think about that. Again, we are concerned with just the abuse of downloadable cards by anti-union labor consultants, and we're not convinced there's a need for those downloadable cards. And then finally, the union's view is that with different literacy levels among farm worker populations, that the union or third party that is not an employer should be allowed to help a worker fill out a union authorization card. Oftentimes we have workers that are able to write their name and sign their name, but they may not necessarily be able to write the name of their employer or their address. So it's common practice for the union representative or a family member to assist workers in filling out cards. We think that should be explicitly provided for as permissible under the board's regulations. So we would urge the board to adopt language to that effect. With respect to signing of the cards, there may be really extraordinary circumstances where someone helps a worker sign a card. Our preference as a union is to ask that the worker sign the card at all times. We have never liked any type of union involvement in signing cards, even if a worker only puts an X on a card. We had a worker that used to sign his name by drawing a picture of a card on the signature block. Unless there's some reason a worker can't sign a card, I think we're generally more comfortable having the workers sign cards because we don't want to be accused, the union doesn't want to be accused of signing cards for workers. So we always ask workers to sign cards, even if they put like some kind of mark that's an X or a Y or something like that. So that's our view on both the format of cards and assistance in signing cards, but we don't want to see objections filed because the union wrote the name of the employer, the labor contractor, or truthfully wrote the name of the date on the card. Those are things that we think can be handled with a regulation that takes care of that issue. So with that, I don't know if the board has any specific questions. Like I said, we do have much broader comments in our written comments, but those were the areas that we really wanted to address with the board and see if the board had any concerns or questions on those issues.
Thank you for your comment, Mr. Martinez. I do know Member Lightstone, you have a question?
Yeah, I wanted to go back to the beginning of comments when we were talking about the tally, and you were raising your comments about whether or not the regional director should share the tally. In the course of that discussion, I thought I heard you say that in terms of the eligibility lists, that you were okay with the way that's being done in some way. And I think the written comments, as I thought I saw them, you were, in the written comments, you were objecting to providing the names of workers who are added on to eligibility. at the end of the process, by the RD. And so I just wanted to get you to clarify what your thinking is on that.
Yeah, and I apologize if my written comments weren't as clear as they should have been. I think what our concern was with sharing declarations of the worker that's deemed eligible. So, so as the board knows, generally declarations are not provided to either party, union or the employer, until the worker testifies at a board proceeding. So the current regulation would actually require the regional director to provide the declaration of the worker that is found eligible. So we were objecting to that, to providing the declaration of the worker that's found eligible. We think that's inconsistent with the board's current regulations and the board's Jamara rule, which protects against providing declarations of farm workers until they testify at a hearing.
Thank you for clarifying that.
Yeah, no, thank you for the question.
I don't have any other questions.
Just a point of clarification, Mr. Martinez, with regards to the 48-hour employer response and also the 5-day response period afforded the regional director, the principal objection is that it's beyond the scope or authority of the board to be able to essentially look at those timelines as flexible timelines. Is that correct? Did I understand that correctly?
Yes, that's our main argument, and of course, we have other concerns, but that's the main argument, that the legislature set these timelines, and it seems to me that the regional directors have been relying on existing regulations, but the regulations can't trump what a statute says.
Okay, thank you. Any other questions from? Again, thank you so very much for taking the time and for your comments. We appreciate it.
Thank you.
Santiago, do we have any other members of the public that have indicated they'd like to make comment?
Not receive any emails. However, there are quite a few folks in the meeting. I would ask that if they wish to make comment, now's the time to either raise their hand or indicate by chat that they wish to do so. Not seeing anyone.
Okay, going once, going twice. Okay, well, with that, we do want to remind those interested in making comment that the written comment period closes on July 22nd at 5 p.m. And seeing and hearing no more requests to make public comment on this matter, we will move on. And the next agenda item is general public comment. So at this time, if anybody wishes to make any other public comment, please indicate either using the chat function, raise hand function, or by emailing Santiago. And I'll turn to you, Santiago, to see if you've received anything.
Reviewing now, no one.
Okay, well, moving forward with announcements, please note the next board meeting is scheduled for Thursday, July 18th at 10 a.m. And with that being said, and our business being done for the day, this meeting is adjourned at 10:56 a.m. Thank you all and have a great day.
Thank you.